Hello everyone, my name is Jenny Huyền Lê, the CEO of IBID company. So it's my pleasure to have the opportunity to welcome Ms. Nataliya Rymer to IBID office today. So Nataliya have intensive experience in immigration law and particularly in EB-5 program. I have had the privilege to work with Nataliya, I think, since 2010.
Yeah, long time.
Yeah, it's very long time. Nataliya, it's wonderful to see you again and welcome to Vietnam.
Thank you so much, and thank you. Hello, everyone, and thank you for having me. And I'm very excited to be here in your offices and see everyone again, my first time since COVID. And I'm excited to talk about EB-5 and answer any questions that you have.
That's great. So actually, I would like to take the opportunity to discuss a little bit about the Uscis guideline on adjudication cases from Vietnamese investor. So I think Uscis is ramping up its activity, evidenced by IBID have more than 20 cases get approved I-526 in the last 30 days, I think. So
fabulous.
Thank you. Interestingly, so I see Uscis, Vietnamese investor use a lot of them use the similar the transfer of the fund. However, some investor get approved, but some investor get denied by Uscis. Can you share with us a little bit, like based on what's the guideline and how it affects to Uscis decision on adjudication case?
Yeah. So I think this is a very good question. And just to step back a little bit, in theory, the Immigration Service understands in Vietnam a lot of business is still transacted in cash, and so the types of records that would exist in transactions that is done, via bank transfer, credit card, or something like that, often does not exist in Vietnamese cases. But in terms of Immigration Services expectation currently for what they want to see in the cases, they want to see as many records as possible. So if there is, in fact, a cash transaction involved, they want to see 7 years of employment records, 7 years of social insurance records. They want to see bank statements. They want to see everything surrounding the transaction so that they can understand how the investor came by the funds that they then transacted with in cash. And then, of course, as you said, in terms of the path of the funds to the United States, a lot of the investors do use licensed money exchangers, and the Immigration Service has had some inconsistencies with adjudicating some of these cases and approving them, and then requesting evidence from others, and then yet some other ones have been denied. Now, there are a couple of reasons for this that we have seen. I'll start with number one. And number one is documenting the case. And I will come back to this point throughout our conversation, regardless of the question. But documenting the case is extremely important. And how the evidence is gathered, presented, put together, is very, very important for the success of the case. As you know, we have been quite successful in having these types of cases approved, and we, as a result, have been asked to handle many, many cases that were not cases that we initially filed, because of the way that we really make sure to lay out the evidence that this is a licensed exchangers, all of the documents pertaining to that, all of the information about how this entity is regulated and what it's subject to, all of the information and documents about how the transactions occur and how the way that they occur is in line with all of those laws that those licensed money exchangers are subject to. And every time we have backup evidence, and then of course there's the legal argument, that we do of course include about, you're making an error, you're making errors of fact, you're making errors of law, but those are not the only things that we're putting into our responses. We have seen other attorneys, only do a little bit of the documents or only go back with the legal arguments, and a lot of the time this is not successful. Immigration service officers may not truly understand what is going on, so each and every response is an opportunity to educate them on the applicable laws and policy that Immigration Service had before, and the surrounding, not just the immigration laws, but the surrounding laws, right? Because we have finance, we have anti-corruption, we have what is someone's property, what kind of, what can we say is someone's, owns this, it's someone's money. They're all American people, so if I go to Western Union, right, and I give them my money to send to my cousin in Arkansas, my cousin in Arkansas doesn't have my money when they go to pick it up, right? The money doesn't walk over across the, across the United States. So this is all an opportunity to educate, right? And being thorough and putting everything together is essential in having the best chance of success. Another reason, though, for these inconsistencies is that the Immigration Service itself does not really provide a sufficient amount of training to its own adjudicators. And many of the adjudicators that worked before COVID in the IPO, the department that adjudicates EB-5 petitions, they left, and the new officers are not properly trained and taught about EB-5 issues. They don't have the resources to do that. So it is a lot of the time different adjudicators, different officers get different cases and do different things with it. And this is why it's, this is this wide difference sometimes in the results, right? But I would caution very much against saying, well, you approved these 5 cases, Immigration Service, and here's your case numbers. Why aren't you approving this case? Because now you're giving them the opportunity to go back and look back at those other cases, and who knows what they're going to do with them. We concentrate on, the law says each case is adjudicated on its own merits, so we treat each case as its own opportunity to educate the agency about what the law is, what the rules are, how this should work, and where they made the mistake. And we have so far been successful.
Yeah. So based on your opinion, so I think it's good that the lawyer have experience working with the investor from specific country. This is like Vietnam. You have been working with Vietnamese investor like 14 years. So you have very long time. So you have experience to understand about the sort of the fund, the part of the fund from of Vietnamese. And also, I have been working with you for many years, so I know like you present the case very carefully, just like you said. You give the officer a whole picture from how to get the money,
Yes.
yeah, how they sell it, how they transfer it in detail, just like educated.
Yes. Yes.
So that's why the approval rate at IBID with your law firm is really, really, really high in the past. And
well, I think it's both, you know, IBID and GT working together, because there's nothing more important than having an experienced agent in the market who knows the issues with the immigration service adjudication, but also the reality of the investors here in this market, and can really work closely with them to look at source of funds, to see if there's a problem, then to come to us and flag, you know, is this okay? And that takes a lot of experience, and your team has that experience, and I think really we should be taking together credit for the level of success that we have had.
Thank you very much. So, talking a little bit about for the investor who get denied at their I-526 state, so is there any like options for them to overcome the decision from USCIS?
Well, yes, there is an option of filing an appeal to the Administrative Appeals Office, or AAO for short. This is something that you know, the law provides for, and really under the new law, which we'll talk about later, is required. If you want ultimately to appeal this further into federal court system, the denial, you have to go and appeal it to the AAO. We have worked on a number of Administrative Appeals Office appeals together, and we do treat them sort of very similarly to the RFE, although, you know, it depends where we got the case, right? So if we're taking over the case, we will review what was provided at the outset, and then we will review the request for evidence, and then we will review what was in the response to the request for evidence in terms of arguments and documents. And then we put together accordingly. Perhaps we need more documents. Perhaps some arguments need to be, you know, expanded. And we build, you know, I think of it like a house. You know, when you build a house, you have to build it one level at a time. So that's how we treat, you know, these appeals. We address all of the issues, and if new evidence is needed, we include that as well.
So, at AAO state or federal courts, maybe we can use like provide more like new document or argue with the courts about the pass of the fund from Vietnam. However, I believe that at the IBID state, like usually the lawyer have already provide as much as document as they can. So, for example, if the one investor have no new document to provide to AAO office or federal courts, so you think that they should take the opportunity to file the lawsuits, or they have to accept the decision?
Right. So if we are talking about a 5 to 6 denial, right?
Yeah.
Then the only way to go to federal court right now under this new law is after the AAO.
After the AAO, yeah.
Each and every appeal and a decision, if an appeal is worth it, right, has to be assessed on an individual basis, right? And I think you've seen us do that, and we are very honest about, you know, we can put this together, but the chances of this are, you know, okay or not so good because we don't have essential documents. Every time an investor decides to spend more money on these steps, there needs to be an honest and serious conversation about what do we believe the chance of success is, what are the issues here, what can we do, because the AAO appeals can take a while, right? They take some time because the Immigration Service is very backed up, and we don't want the investor to spend all of that time and then wait and just to get, not a positive result that they didn't know was coming,
Yeah, I understand. So do you think, like, for those who already get denied, so you think what the best way they can do?
Well, I think it depends on what the basis of denial is. That's what really makes it important to review each case very carefully. So if there is an argument about a mistake that the Immigration Service made in the adjudication, and maybe not so many documents were provided, but good enough documents were provided, then potentially it makes sense, right, to go forward and appeal the case, because you have all of the proper, things done, and there is a good amount of documents backing it up, and it should be by regulation and the new law enough and sufficient to approve. So we would recommend to appeal. If we don't have, and there is an issue with the denial that is such that an appeal is not going to resolve it, potentially the best thing to do is consider refiling under the new law, which we'll talk about in a minute. There are new visa set-asides, and the filings under those in projects that are subject to the set-asides are getting approved fairly quickly, and so chances are that somebody could file a new EB-5 petition and be approved before even their AAO denial or a decision could even come out, right? So it depends on the case.
It depends on what the officer writes on the denial letter from USCIS to see if they should file appeal or not. So, however, there are some investors contact to me with their case denied and asking me if they can use the refund amount from their I-526 denied to reapply to new I-526. So what do you think? They worried us because the source of the fund already denied by USCIS. Can they use the source of the fund to reapply again?
Well, it depends on why the denial was issued in the first place, right? If there was a true issue with the source of funds that we also will flag looking at it, then no, definitely.
How about the part of the fund? How about their I-526 denied but the part of the fund?
If the 526 was denied for the path of the funds, but the source of the funds was acknowledged as lawful by the Immigration Service, and the funds are returned, then they would still have to reinvest in a new
amount.
Right.
Yeah.
So there would be a new path of the funds. And we would just, they would work with you to make sure that the path of the funds is not a problem.
No, right? I see. So for those investors who have I-526 denied, I think it's the best way to contact to your lawyer to see if you can reuse your investment fund to reapply to the new EB-5 or not. Thank you so much, Ms. Nataliya, for your helpful information.
Of course.